Well, my name's Jack Day. My legal name is John Wilkins Day. I've always been known as Jack, which for some reason people find somewhat confusing. I did my law practice, as are my bank accounts and my house and things like that, uh, in the name of John W. Day. But since I'm known as Jack, when I ran for judge, I decided to do it under the name Jack, which is how people knew me. I realized that Jimmy Carter and Jeb Bush had done that, so it must be okay. And then ultimately, after I became a judge, I just for uniformity's sake, I got the Florida bar to change my records. So my Florida bar name is Jack Day.
You are Judge Jack Day,
I am.
and you grew up in St. Petersburg, Florida.
I did.
Where'd you live when you were growing up?
We always lived, in fact, I still live in Northeast St. Pete. My earliest memories are a house that we were in from my earliest memories until second grade. We moved to the house I lived in about about a mile away, where I lived until I graduated high school. And really, the house is still in the family. When my mother died, my sister bought out my other sister and me. So they haven't gone far within the county.
What was family life like for you as you were growing up in St. Petersburg?
Well, my father was an insurance agent. He was very much a self-made man, an entrepreneur, type A personality, very hardworking, sort of business. My mother was very supportive of that. She was kind of from the generation where I think if she had come from the next generation, she would have had a separate career, because she was a very, very bright, able woman. She did a lot to help my dad in his business. And a lawyer friend who had represented my dad's business told me pretty good description. He said my dad was like fire and my mom was like water. They complemented each other, but sometimes it was a little bumpy. They had a satisfactory marriage. They were together till my father died in 1981. But I think my marriage is more happy than theirs was.
So you graduated from Northeast High School, class of 1966.
Vikings.
And after high school, you went to the University of Florida, where you earned a BA in English in 1971.
That is correct.
Was English always your major when you were at college?
No, I started out as I went to college planning to major in engineering. I had a pretty good science and math background. So I thought that was the way to go. I liked that. What drew me to engineering was the creative idea, the creative aspect of engineering, which is there, but you don't get to it. You don't get to it in the first couple of years of engineering study very much, and it was not a good fit for me. I went through chemistry and then sort of gravitated more and more to literature and English. I'm a big believer that literature and the arts are not fundamentally entertainment. They're a statement. They're a representation of how we live our lives, what it is to be human, that sort of thing. That's why they call it. Maybe that's why they call it the humanities. And so that was my interest, and it was my interest after college as well. I went to grad school intending to get a PhD in interdisciplinary humanities area. I went to Emory, and I was about as ill-suited to becoming a professional academic as I was to being an engineer. It didn't really take, and I dropped out. I'd had an early interest in, as a young kid, in law, and actually I was dropping out of Emory. I took what was called the Cooter Preference Test. If you've ever heard of that. Would you rather go to a museum or take a hike in the woods? Would you rather paint a picture or be a forest ranger, whatever? And I it gave me some guidance. It didn't say I should be a lawyer. A lawyer was about number 6 or 7, but it was in the top. It was in the top clump. Number 1 was being a psychiatric social worker.
How old were you when you knew for certain that you wanted to be a lawyer?
For certain, when after I'd started law school, because I started it kind of experimentally. I was still kind of an academic snob. I didn't want to go to a trade school. I wanted to intellectual discipline and all that, and I found that it satisfied me that way. Not apart from being practical, I was drawn to the aspects of law as a sort of applied social sciences in a sense, you know.
So you went to law school at the University of Florida, and you graduated in 1977 with a JD degree?
Right.
What was your favorite class in law school?
Torts.
Why was that your favorite class?
Well, it came early on, so it was writing on a blank slate since it was a first-year course. But torts deals with, first of all, it was something I was not acquainted with. You know, everybody has, in our society, has some inkling of the criminal law and even some idea what a contract is. But what's torts? And torts is the issue of grieving about or remedying alleged civil wrongs that aren't the function of a contract, and I've found that very interesting. And then, of course, as you know, when you study torts, you're studying history because you start with English common law stuff and go into the 19th century, and you sort of have the law developing in relation to the Industrial Revolution and all kinds of social trends, and it's I liked it.
What was your least favorite class in law school?
Probably corporations. I've now been in the law, licensed in the law over 40 years, and I still have trouble with the idea of writing certain things on paper and creating a person. Which, of course, a corporation being an artificial person. I've managed to work with, you know, I've reached my peace with corporate law and corporate things. I've done okay with it as a judge, but it was not something I was drawn to.
After law school, you became a prosecutor in Sarasota?
Very briefly. My first job offer went down to a guy named Jim Gardner. He was the newly elected state attorney. It was a little unusual because he had been the public defender. He'd just taken office, so he was planting on fresh turned ground, and it was kind of neat. But I wasn't there very long. I got an offer that sounded like my dream opportunity. About 9 months or so after I was there, and Mr. Gardner graciously let me out of my unspoken commitment to be there for a while, and so I was actually a prosecutor for less than a year. I did second chair a murder case because it was a small office, but I was primarily kind of a briefcase carrier on that. Otherwise, it was all misdemeanor court. DUIs.
You left, and you began what turned out to be a very long career in civil practice?
That's true. I did a little criminal after that, but by and large, and I did. In fact, the dream job that was with a practitioner in Tampa, and we did some administrative law there, as well as civil. But basically, civil was always dominant, and by the early 80s, it was exclusively, or mid 80s anyway, exclusively civil.
All told, what areas of law did you practice in as a private practitioner?
Well, you want to count things that I did once or twice?
Sure.
I mean, I've written wills. I've done real estate closings. This is at the end of the spectrum involving things I did seldom. Adoptions, few criminal cases. I had one criminal case that I was pretty pleased with. I didn't actually handle the trial, but I handled the appeal and the resentencing and got a big reduction on the sentence. It was shortly after the guideline the guideline regimen came into being. I did divorces and custody work, but those were all in the minority compared to insurance defense, plaintiff's personal injury work, insurance defense, and some commercial litigation, but kind of the small business end of commercial litigation. A business owner who's been stiffed by a client and who needs to be sued, who didn't pay him, and there's a dispute about payment. Not sophisticated transactions between big companies.
How long did you practice law before you became a judge?
29 years. At least that's what I recall figuring out. So it'd be 77 to 07. Yeah, 29 years.
Was that all in the Tampa Bay area?
Yeah. I left Sarasota, where I was the prosecutor, in less than a year. Went to Tampa. Was in Tampa in sort of the dream job that wasn't. Not very long, I think about 2 years, came to St. Pete and actually went into practice for myself for a period of time. Then I was in a small 4-lawyer partnership that also was not a match made in heaven. That didn't last too long. Then I went with an insurance defense firm as sort of a senior, but then I wasn't really associate material because I'd been out 5 years, I guess, or no, about 6 or 7 years at that point. I was an associate with a firm called Lyle & Skipper. I became a partner in the firm, moved to the Tampa, that was St. Pete, moved to Tampa again in like 88. Left that firm in 90 or thereabouts and went in-house with an insurance company doing catastrophic cases, leg offs, amputations and deaths and things like that for defense. That was the Cigna companies. They left the liability insurance business about 4 years after that, and that led to my hooking up. Meantime, my old law firm, Lyle & Skipper, had dissolved. One of those names, Chester Skipper, along with his son, my friend Lee Skipper, Jesse Skipper, the three of us formed a firm called Skipper and Day, which was my next gig. That was back in St. Pete for about 6 years. We all decided we just weren't making enough money in that business model. And I then went back out on my own, but I was in an of-counsel arrangement with an old friend named George Roddert. Not a member of his firm, but of counsel to the firm, where I kind of brought my area of expertise to help, support some of their stuff. And that was my situation when I when I unsuccessfully ran for judge in 04 and successfully ran for judge in 06.
You've got a special connection to Cuba that goes back to at least 1964. What is that?
In 1962, my parents, well, I have to give you some context. Castro took over in Cuba in 59. There was a period of time when Cuban families who the parents couldn't get out, but they could get the kids out. Later on, I learned this was called Operation Pedro Pan, like Peter Pan. So in 62, we acquired my parents acquired two foster children. I acquired two foster brothers, William and Osvaldo, Willie and Ozzy. And they lived with my family for about, well, let's see, 4 or 5 years. Ozzy went on to actually manage my father's business. Willie married and we lived in Tampa for a long time. He's moved to Puerto Rico. Ozzy lives in St. Pete Beach, and we're still in touch. So I studied quite a bit of Spanish in school, but through them I developed I speak Cuban Spanish. I speak Spanish with a Cuban accent, and I cuss like a 15-year-old Cuban boy from the 1960s. We had fun at the dinner table, talking in Spanish in the presence of my parents and sister, saying all kinds of outrageous things in Spanish, as adolescent boys will do to try to top one another. But I've been surprised how the Spanish has stayed with me. It comes up. I had, when I was doing jury selection a couple weeks ago, I had a lady who said she didn't speak English. There was no translator available. The lawyers agreed they wouldn't have any issue about it if I just proceeded, and I asked her a couple questions in Spanish. She was very comfortable. So it comes in handy. It's more than a parlor trick, and it's fun when we travel in Spanish-speaking countries.
So what got you thinking about?
Oh, and I've been to Cuba. Excuse me. I've been to Cuba, but only once. It was a couple of years ago. I'd love to go again.
Okay. So what got you thinking about becoming a judge?
You know, when for the first decade plus, I remember graduating law school thinking I would never want to be a judge because I wouldn't want the pressure of having to be right. You know, a lawyer can advocate for something, and as long as it's within the bounds of law, the lawyer doesn't really have to decide if it's the right thing as long as it's arguable, on the law and the facts. The judge has to decide things. I didn't feel, I think I had more awe of judges. But then after I appeared in front of judges for several years, I was less in awe of judges. I had a sense of, man, I could do at least as well as these guys. So there was that, sort of demythologized it for me. I applied. I applied to be appointed for the first time in, I think it was 94 or thereabouts, sort of naively filling out the application, seeing where the process took me. It didn't take me very far. After that, actually my then wife died 4 years after that. And she'd been progressively more disabled by her central nervous system disease, and I think that that kind of took over things from the early 90s until she died. That was just sort of there wouldn't have been time or energy or wherewithal for anything extracurricular more than just trying to keep the wheels on.
After your wife's passing, you began to actively seek a judgeship?
Yeah, it was actually, it was after that, and it was after I'd remarried. And I'm not going to say, it certainly was not that Nancy pushed me into it, but I think Nancy gave me the confidence to go for it. As you know, it's a very daunting undertaking in many respects, including financially, and maybe most of all for the way you're putting your ego out there at risk.
So you went through the application process.
No, I didn't at that point. I ran for judge in 2004. I had not applied through the JNC process again since I had several years earlier. Maybe 10 years earlier. I ran in 2004. Very major effort. There was a field of 5 candidates, which is, with retrospect, I wouldn't recommend anybody to do. There were three very good candidates whom I defeated, and I lost in the runoff to our colleague Cynthia Newton. Now, after that, having been told that having made a good showing, I would be perceived as a credible candidate for nomination, I went through the JNC process a few times and was nominated to the governor, I think 3 times. At least one of those was for a county court seat. At least, I don't know if it was 2 county and 1 circuit or 2 circuit. I think it was 2 circuit and 1 county. But that political process didn't turn out in my favor. So I ran again in 2006. I was more fortunate in my opposition. At that point, there was only one opponent, and he was a fellow that had run a couple times before and come in second, and he did so again.
And you got 69.3% of the vote.
Did I? I didn't know that.
Did your campaign have a theme?
Well, there's one. Yeah, I in fact in 2004, the phrase, if that's a theme, actually was a phrase, and it kind of has become a theme, philosophically and otherwise. And I owe this to a political consultant that we were brainstorming with, and he came up with the phrase "day in court." You want to have a day in court. People deserve their day in court. There are all kinds of different versions of it. Ever since then, I have a website called dayincourt.us, and I use that email. And after my retirement in a few weeks, I'm intending to use that as my name in mediation, Day in Court Mediations. So that was the cute gimmick, if you will, but it really was more than a cute gimmick, and I came to realize, both in the process of campaigning and even more after I finally became a judge, how important that concept is to me. I really, because it encompasses a lot of things. It encompasses people feeling that they've been heard, and to some extent we're talking about little people and the unrepresented here. But also lawyers need to feel that they've been heard, even if they come in with a weak hand. So it's about being heard. It's about being treated fairly. It's about, I practiced law a lot. I was a lawyer much longer than I've ever been a judge. And it's one thing to go out the door feeling like you were heard and a decision was made and it went against you, versus you weren't heard. So it's important so that's really, like I said, it started as a little buzz phrase, but it's almost become it became like kind of like my judicial philosophy, or part of it anyway.
You won election in 2006 and then again in 2012, and here you are at the end of 12 years.
Yep.
Has it been a good ride for you?
It's been the greatest privilege of my life.
What divisions have you worked in during the span of your judgeship?
Well, initially, my first 2 years I was in felony divisions. Year 1 in Clearwater, year 2 in Newport Richey. That was somewhat challenging. In fact, you remember year 1 because you were one of my prosecutors. So you may have seen me at my worst because I certainly brought my criminal procedure knowledge, such as it was about 8 or 10 years stale at that point at best, maybe 15 years. And So I did a lot of that. That involved a fair amount of on-the-job training. It was a great experience, and probably does a lot. Somebody, not my idea. I've heard somebody express the theory that putting a new judge in a field that they're not familiar with does the most to mold them into what it is to be a judge generically, as opposed to how to do the law that they're most familiar with. And in fact, they may have said that particularly about crime, because let's face it, first of all, it's 90% of the public's idea of what a real judge does, right? And it is, in respects, it's more formal and has, in some respects, more structure, more judicial trappings, I guess, to it. In some respects, anyway. So it was a good experience. And should I go on to what happened next?
Yes.
Okay, after Newport Richie. Nice thing about Newport Richie is that, in contrast, in the criminal divisions of Clearwater, the most serious crimes were sort of funneled somewhat to a major crimes division. In Newport Richie, there was no such thing. And so, I'll never forget in Clearwater sentencing a man to prison who scored for prison on felony shoplifting of lobster tails and filet mignon. We didn't have guys like that in Newport Richie. We had child molesters and attempted murderers and people like that. So it was a little more. It felt a little more substantial in that respect, but I was on the road commuting over 2 hours a day, so I was glad to come back from Newport Richie, returned to the County Justice Center, and had another complete transition to Unified Family Court, which, as you know, is a mix of juvenile delinquency and juvenile dependency. And in many ways, I felt like that was some of the most important stuff I've done as a judge, particularly in the dependency area. I think it's an area of law that gets short shrift in terms of resources and attention and the like, because it's impacting people who are going to be our neighbors and citizens, and it's trying to give them a fair shake in life when they're starting maybe with a lot of strikes against them.
What has been your favorite division?
Well, notwithstanding what I just said about UFC, I mean, look, I was board certified in civil trial. I tried civil cases. I did civil work. I love torts, as I said. I love the law of evidence. I love the rules of civil procedure. So coming here, downtown St. Pete, in a civil division where I did the largest portion of my private law practice, absolutely it's been the best. It's been a great fit for me, I think.
Has being a judge been what you expected it would be before you became a judge?
No. I mean, not in many ways. No, particularly in sort of trivial ways. I had a little talk that I've given a few times, though not recently. I can't do it off the top of my head, but it was about 12 things I learned after I became a judge that I wish I knew when I was practicing law. And the first one was about never stop a judge to chat as he's exiting the courtroom, because he might have to go to the bathroom, But the others were more serious than that. But I got so much in there. There's so many things I would have done differently as a lawyer in terms of advocating before a judge. And the two surprises that come to mind. One is what I would tell lawyers about advocacy, and it's that really and truly try to imagine that you have the judge's job and now think about what's the information he or she needs to hear, and what's the way that helps you most for them to hear it, both in terms of facts and law. The other surprise to me that I've commented on to people is how much a judge's work is like working on an assembly line. In two respects. First, there are things that happen upstream that you have no hand in, and you may not even be aware of, and you can only speculate about. And likewise, there are things that happen downstream that are out of your control. So you have this little snapshot when the product is passing through your hands. The other way it's like an assembly line is that it's critical that you not stop the line from moving. You have to keep it moving. I tell people, judges don't get paid to always get it right. They get paid to keep it moving. Which sounds a little cynical, but I mean, it's like, people make the balls and strikes analogy that judges call balls and strikes. Even if the umpire makes the wrong call, the game can continue. If the umpire freezes, the game comes to an end. So that's the assembly line analogy, and I really had not appreciated that. I think lawyers still don't appreciate the sort of volume of pressure that we have of other litigants and other cases. Lawyers come in and think you remember. Sometimes they think you remember a lot more about their case from last time than you do. I compare, and this is one of the fun things about judging. It's like watching really good television where the channel changes every half hour to a different show. And the only way you can engage with that show is to sort of have your brain like a random access memory that dumps what you don't need to clear the space for the next thing as it's coming in. So yeah, it is not a disparaging analogy to compare it to an assembly line. It's maybe a more flattering or appropriate analogy would compare it to a smorgasbord of really interesting but very different dishes moving along.
What have you liked most about being a judge?
Well, I think I just told you, kind of the stimulation of that, particularly when they're good lawyers, when they're good lawyers on each side or on the multiple sides, doing good work, polished professional work. I mean, it's to me it's like a aesthetic experience and a sporting experience, and I had the best seat in the theater or in the house, whatever you want to put it, and just seeing because that's to me it's not just entertaining. It's the advocacy system working the way it's supposed to work, and it's a great pleasure to observe.
What have you liked least?
Well, at the trivial end, what comes to mind is particularly in civil, but I think in all areas, in every area I've worked in, there's an awful lot of my day. Not often, maybe 30 minutes of my day, every day goes for essentially mechanical rubber stamp work. For example, in the civil area, lawyers generally don't like to mediate their cases without an order to mediation, even though they agree on it. They agree on lots of things. Then they send me an agreed order to sign to order them to do what they've already agreed to. I've been known to tell them, look, you guys, you could send one another a letter just to confirm, and then the other one, that's enough to keep somebody from reneging, especially if you have a good relationship, but they want that. When they settle a case, they want an order of dismissal. The rules of procedure even say that the plaintiff can dismiss his case with prejudice, bing, bang, bong, but they want to stipulate and have an order they can show their client. So that's the trivial end. More seriously, unprepared lawyers, lawyers who knowingly or unknowingly, but especially when it's knowingly, try to persuade you to do what is not the law. In other words, and this is in the appellate law, there's a term for this, which I'm drawing a blank on right now, invited error, where they invite you into error. But short of that is where they want the win so bad, they will ask you to do something that might indeed be reversible error if you allowed it. But I don't worry about being reversed, but I do worry about not doing a good job. There's kind of a difference.
In your time as a judge, what is the most difficult decision you've had to make?
Well, the kind of nice thing about civil work is that you're only dealing with money. Now, you deal with more painful things when you're dealing with things like evictions or foreclosures, where people are losing their homes. But even so, that's still pretty dispassionate compared to what comes up in unified family court, dependency court, where I probably terminated the rights of parents, I don't know, a dozen times in 4 years. It could be twice that. I don't think so. At least in contested actions, it's probably 12 or 15 times after a trial. And that's very hard. The facts that support that are very hard. Times that custody decisions, kids that wanted desperately to go back to their parent, and I concluded on the law and the facts that would be a bad thing. Or kids who desperately did not want to go back to their parent, and on the law and the facts, maybe I had to let the parents have them. I mean, that's, these are the little ones. These are the little helpless ones that, I've always run away from biblical analogies to judges. But if you think about sort of a biblical judge, or a king or somebody doing justice and mercy to the little people, I mean, the children and the innocent, when you're doing things that impact their lives, those are tough decisions. I don't have any one that stands out, but a lot of them were tough, and you just pray you did the right thing.
Has anything about the courtroom and the people in it changed since you became a judge?
Well, I haven't been a judge all that long, and I've been in 3 different kinds of courtrooms in 12 years. So I would say no, not in the time I've been a judge. I think in the time I've been a lawyer and at the time I've been appearing in court, I think there may be a little less formality, a little less rigidity on some things, but not in a bad way. It's probably just part of society changing over time. I don't have any issues about it.
What have you observed to be the most common courtroom mistakes made by attorneys?
Well, I participate. I have like 3 times, I think, at a seminar in Tampa with judges on a panel, and the lawyers come. The lawyers like it. The judges just get up there and kind of pontificate, but the lawyers like to get feedback about what the judges feel works and doesn't work. But then it's hard to kind of tick off a list. And I'm thinking about in terms, you said the courtroom, so to me that means jury trials. In fact, I don't know, that's about all I do in the courtroom.
Or any hearing.
Well, in a hearing, I've already said that, it's a mistake. I'll do the negative of what I said before. It's a good thing to think about what the judge ought to hear. It's a mistake not to think about that. It's a mistake to go in and think. And I'll tell you a mistake, and I used to make this one myself. It's not that common, but when you've done it yourself, you're particularly aware of it. It's where you've got maybe 3 points, and the judge really likes this one, and you want to say, well, yeah, that's good, Judge, but let me tell you about this over here. That's a mistake. That's a mistake in advocacy. If you're selling your product and the customer it likes this one feature, that's the one you want to talk about, especially if the customer thinks that's dispositive of the issue. But that's not the worst mistake. I mean, the worst mistakes are they're things that would make most of us blush, or be ashamed, or be horrified. Sloppiness, laziness, lack of preparation, lack of dignity, lack of just a total obliviousness to consideration of other people, particularly a witness. Then there's things like, asking really stupid questions, and, the cliche ones like asking the cross-examination question you don't know the answer to and things like that. I saw a pretty good lawyer earlier this year start apologizing to a jury and jury selection for the fact that some of his witnesses were appearing by deposition, and asking them if that would bother them. I'm sure it would have never occurred to them to be put off by that had he not planted that seed. And by the time he got done, a couple of them were saying, yeah, I think I might think less of you if you have them up here. So you can, trying too hard, lacking balance, with a jury or with a judge, seizing, trying too hard on weaker points. I guess not choosing your battles is a big one and a common one. Even pretty seasoned lawyers sometimes, they'll come in with their hobby horse issue that's a loser for them. And they'll have other things that are strong. And one thing that can happen if you've got several issues that are going to come up say in the course of a trial or the course of a case where you're coming back for repeated hearings, you can lose credibility. If you become the guy that comes in or gal that comes in arguing the weak hand again and again, fighting the tilting at the windmills. Eventually, that becomes your moniker. You're the person that tilts the windmills, and when you come in, it's kind of like crying wolf. You come in with something valid, you're just going to have a harder time being credible. Of course, that goes a fortiori for things like, God forbid, misrepresenting the law or the facts, or citing law that's been reversed. I had a lawyer once cite me a rule that had been repealed 12 years earlier. And it wasn't on the spot either. I told her to come back, and the issue came up. I said, well, I'm going to do this, but I'll give you time to research it and come back and show me what it is. She came back with this thing. I looked it up. It had been repealed, eliminated 12 years earlier. I was offended by that.
How important is it for an attorney and an attorney's client to make a good first impression on a judge?
Well, we all know that first impressions are lasting impressions and all of that. And I think that's true. I'll take a little bit of a contrarian position, though. I think having made bad impressions on judges sometimes when I was practicing, maybe I really try to give people more than one bite of the apple in terms of coming back and redeeming themselves. Anybody can have a bad day. Anybody can have a time they come in and they're not as up on their game for whatever reason as they should be. But having said that, I guess that really underscores the basic point, which is that generally speaking, the first impression is going to be the one you're going to have to deal with thereafter. And if you don't do well first time around, you're going to have that much more of an uphill fight, even if you're dealing with somebody that gives second chances.
What, in your opinion, are the top traits of a good judge and of a bad judge?
I think patience is very important in a judge. I think fundamentally, to be a good judge requires humility. The lawyers and the people, especially when you are literally sitting in judgment of people, you need to remember the, the mote or beam in your own eye first. And I feel very strongly knowledge of the law. I think true we can have the lawyers hope that the lawyers will educate us on the law, but we should be scholars of the law, ideally at least. Worst qualities I've already alluded to. Pet peeve of mine as and I may have I've often had the feeling that I may have bent back the other way in reaction to some things I did not like as a practitioner appearing before judges. So maybe my pet peeves that I didn't like to experience at the hands of judges were not listening, not understanding, jumping to conclusions, and what I call mechanical thinking, which to me is kind of an application of the law as a rigid black and white cookbook that fails to appreciate the nuances of the law. And playing favorites. I mean, I guess it'd be naive to think that doesn't happen. I know I've seen it happen as a practitioner. I guess it still happens, and that maybe should go to the top of the list of what a judge shouldn't do.
Do you feel that you've made a difference as a judge?
Well, it's funny. I much as I've enjoyed the civil work, it's sort of like the going back to the what was your tough decision question. I reverted to the family court because, Blake said something like, "He who would do good to his fellow man must do so in small particulars." I have a fairly good sense that I affected some lives in a favorable way when I was doing the Unified Family Court. And I feel good about that, even though I didn't relish the work as much as I do the civil work. In the civil work, it's a little less primal. The way I think I've made a difference. I think I've done a good thing, but I think more in terms of making a difference in teaching lawyers to be better lawyers sometimes, and at the risk of seeming immodest, hopefully at some time, in some instances at least, modeling good behavior, modeling good judging. I like to think that, somewhere, someday, a lawyer is going to be saying to another lawyer, well, here's the way Judge Day handled this. Let's do it this way, or let's suggest this to the judge in this case, something like that.
Do you have any specific plans for after you retire?
Oh yeah. Well, let me say, anybody who retired without specific plans would be heading for a major disaster, I think. And I learned the phrase a couple of years ago. You don't want to retire just from something; you want to retire to something. And I'm kind of excited about resuming mediation practice, which I did a lot of before I took the bench, and which to some extent is there's there's kind of an enhanced market on some lawyers' part to use mediators who have served as judges. So I'm excited about that. I'm excited about sleeping in more often. I'm excited about traveling, have more time with my family. We are big travelers. We want to go to Australia. We've got quite a list of places we want to go to that we haven't been to, and we have kids and grandkids in 3 cities around the country. Not counting my daughter and grandson here in town. I look forward to spending more time with all of them.
Will you become a senior judge after you retire?
I always looked forward to that, and as you know, one cannot serve as a senior judge and a mediator in the same circuit. I intend to qualify as a senior judge. If my mediation goes the way I hope, I'll be mediating in the Bay Area, the Tampa Bay area, so I wouldn't be able to serve as a senior judge in the 6th or 13th or 12th judicial circuits. But that leaves a lot of other places where maybe I could line up a visiting judge gig. I'd like to do that, but I don't know how that's going to work out.
Is there anything else that you'd like to say?
I think I've said it. If I were an author, I'd say I'd like my body of work to speak for itself. I don't know if that's realistic, but I think this is a good thing that you're doing and recording this history for whatever it may be worth to whatever insights it may give other people. I said it's been a privilege. It's also been a blessing, and being a judge has been, after my family, it's been the greatest joy of my life.